Hello everyone. I, Forum Patel from LG School of Law, would like to extend my warm welcome to every viewer in the second session of the intellectual property rights. Now my friends, in the last session we discussed about the concept of the intellectual property, what is intellectual property rights, different kinds of the intellectual property, and a very brief introduction about all those kinds. So in this session I would like to pose a question that how this intellectual property rights has a great evolution in our country, that is in India, and of course how it is helping our economy to be more developed. So friends, let's get started with that understanding. So friends, when we are talking about the history of the intellectual property, we have to go back to the very ancient times. George Alfred D. Penning is supposed to have made the first application for the patent in India in way back in the year 1856. Now, the government of India promulgated the legislation to grant what was then termed as the exclusive privilege for the encouragement of the invention of new manufacturers. That is the Patents Act. Now on March 3, 1856, a civil engineer, of course George Alfred D. Penning's, Calcutta petitioned the government of India for grant of the exclusive privileges for his invention. Now, these specifications were one of the very few kinds which gave the kickstart to the concept of the intellectual property in our country. When we are talking about the concept of the copyright, my friends, modern copyright law developed in India gradually, of course, in the span of more than 150 years. Copyright law enacted in India was in 1847 through an enactment during the East India Company's regime. According to 1847 enactment, my friends, the term copyright was for the lifetime of the author plus 7-year post-mortem. But in no case could the total term of the copyright exceed the period of 42 years. The government could grant a compulsory license to publish a book if the owner of the copyright upon the death of the author refuses to allow the publication. Now the act of the infringement compromised in a person's unauthorized printing of a copyright work for sale or hire or for selling or publishing, etc. were given. Then in 1914, Indian legislature enacted a new Copyright Act which merely extended most portions of the United Kingdom Copyright Act of the 1911. It did, however, made few minor modifications. First, it introduced criminal sanction for the copyright infringement. Second, it modified the scope of the term of the copyright. The 1914 Act was continued with minor adoptions and modifications till 1957 Act, and it was brought into force on 24th January 1958 when we are talking about the copyright particularly. Now, when we talked about the history of the patents in India, the first legislation in India relating to the Patent Act was of the 1856. The objective of this legislation, my friends, was to encourage the inventions of new and useful manufacturers and to introduce the inventions to disclose the secrets of their invention. It was subsequently, this act, my friends, it was subsequently replaced by 1857 since it has been enacted without the approval of the sovereign. Now, fresh legislation for granting exclusive privilege was introduced in 1859. This legislation contains certain modifications for the earlier legislation, of course. This act of 1859, it provided protection for the inventions only and not for the designs, whereas United Kingdom, of course, it had been protecting designs from 1842 onwards. Now, to remove this lacuna, the Patents and Designs Protection Act, it was passed in 1872. This act amended the 1859 Act to include new and original patent or design or the application for such patent to any substances, and in which we tried, of course, to remove the lacuna which we had in the previous law. But in the year 1911, Indian Patents and Design Act, it was brought in replacing all the previous legislations on the patents and designs. This act brought patent administration under the management and controller for the patents for the very first time in our country. After the independence, my friends, the need was felt that the Indian Patent and Design Act had to it was not fulfilling its own objectives. It was found desirable to enact a comprehensive patent law owing to substantial changes in the political and economic conditions of our country. Of course, we had to make certain laws to many of the laws after the independence. So patent laws, or rather the laws, Indian Patent and Designs Act 1911 was no different. And accordingly, the Government of India constituted a committee under the chairman of Honorable Justice Dr. Bakshi Tek Chand, a retired judge of the Lahore High Court in 1949, to review the patent law in India in order to ensure that the patent system is conducive to the national interest. The committee provided its recommendations, and based on the same recommendations, the 1911 Act was amended in 1950 in relation to the working of the invention and compulsory license or revocations. After that, due modifications and amendments were brought in the year 1957 and then later in 1967, and this Act remaining in force for about till 1994 without any change. There an ordinance affecting certain changes. It was required later on post 1994. So subsequently another ordinance was passed in 1999 which replaced the Patents Act. Later on, the third amendment to the Patents Act in 1970 was introduced through the Patent Amendment Ordinance, of course, and it was in effect from 2005. This ordinance was later on replaced by the 2005 Act, which was brought into force from 1st January 2005. Now, this was all about the history of the copyright and patent laws. When we are talking about the intellectual property, how can we forget the trademark concept? While some form of the property protection for marks in India dates back several millennia, Indian statutory trademark law was back to 1860. Prior to 1940, there was no official trademark law in our country. Numerous problems were arised because of that, about the infringement, about of course the passing off, etc., etc. And they were resolved at the time by application of section 54 of the Specific Relief Act, and the registration was obviously adjudicated by obtaining a declaration as to the ownership of the trademark under the Indian Registration Act. Now, there was a specific need to overcome the aforesaid difficulties, and the Indian Trademark Act, therefore it was passed in the year 1940. This corresponded with the English Trademark Act. After this, there was an increasing need for more and more protection of the trademark concept, as there was a major growth in the trade and the commerce. The replacement of this act was of the Trademark and Merchandise Act of 1958. This act, now the 1958 Act, it provided for the registration and better protection of the trademark and for prevention of the use of the fraudulent marks on the merchandise. Now, this law enables the registration of the trademark so that the proprietary of the trademark gets legal right to the exclusive use of the trademark. The objective of this act was very easy registration and of course better protection for the trademark concept in our country. After that, 1999 Act came into force with certain recommendations of the World Trade Organization. Now, this act is to confer the protection to the users of the trademark on its goods and prescribed condition on acquisition, the legal remedy for enforcement of the trademark rights. So friends, this was all about the history of the main intellectual properties, that is copyright, patent and trademark in our country. The whole history, it speaks that first of all there was no concept with regard to the same thing. Later on the need was placed, and then with the social changes and the development that took place in our country, the amendments were made to the laws. So friends, when we are talking about intellectual property, how can we forget that how intellectual property would be beneficial to everybody in our country? So to understand that in an extent, we should understand that what are the intellectual property and how it is important for the economic development in our country. Let's understand that concept. When we are talking about the intellectual property and economic developments, my friends, let's have a look at the bullet points that will be useful for us to understand this whole concept. Frameworks for the insurance of licensed innovation could either improve or constrain the monetary development. Now, my friends, we are very well aware about the concept of the intellectual property by now. So, it is now understood that intellectual property is one of the kind of the property which one person would be owning in that person's name. Now, that would be relevant with the trade aspect. If the property is used in the trade, of course monetary aspect will be considered in that. So economic development and intellectual property, they move hand in hand further on. Trade related aspect of the intellectual property rights are of course one of the best criteria under this. Protected innovation is also an important asset for every single business, particularly those contributing huge totals of the cash towards the innovation work so as to make one kind of the item and administer the same. That means, my friend, when we are even talking about different kinds of the properties, that would include the patent or other innovations. So, if any company is investing huge amount in their R&D, that is research and development programs, if the intellectual property ratio is very high in that company, the economic development for that product of that company would of course go very high. They both are hands in hand on the equal footage, and that is the reason that once the economical protection or once the economic is going very high, the effect will be there in the intellectual property R&D, and if the R&D is going very too good, way too good, then the economic development of that particular industry or that particular company would also be very high in nature. To receive the financial rewards of the IPR, organizations ought to proactively execute the licensed innovation arrangements. This permits them to distribute the novel one-of-the-kind manifestation and furthermore increment their income. It is likewise essential to characterize the licensed innovation objectively, plainly, as it can assist organizations with accomplishing their business goals. That means, my friends, that now we are talking about having the license of that property. If I have created a particular intellectual property in my name, and if I am creating a license to distribute the same property to any other person who is giving me due credit, of course, in many other forms, so that would boost up my economic development and of course the economic development of the person who is taking license from me. Reason being, the creation, the product will be innovative in its own nature. That is the reason the use of that product must be having certain solutions to certain problems, and to use that property would be of the prime importance. So when we are talking about the development aspect, it is not only about economic development. If the intellectual property or the kickstart is given to that kind of property, the innovations, if we are giving that kind of environment to have that good innovations or other good creations in the market, then of course it is going to help the economy to boost up very high. It is applicable to many different sectors and rather every sector, because every creation is very important. That is the reason that economic development and intellectual property rights, they increase or rather they grow hand in hand gradually. This was all about the IP and economic development, and of course the history of the intellectual property in our country. Friends, in the next session, we shall be dealing with the IPR and international conventions which are available in the market. Till then, you guys stay tuned and take care. Keep learning.